Hey everybody, Arizona attorney David Volson here, and in this video I want to talk to you a little bit about some new developments in Arizona law, or at least new developments as of March of 2018, which is when this video is being filmed, so if you're seeing this way later, then it may not be such a new development. But this is all centered around the idea of joint legal decision-making, sole legal decision-making, and joint legal decision-making with final say. So the basic idea here is that in Arizona, anytime you have a decision to be made about a child that involves some legal choice, so where does this kid go to school, what doctor is the kid going to, that sort of thing, when you're making a legal decision about the child, in a vacuum by statute, we have two different options. There's joint legal decision-making, where both parents are supposed to have equal say, they both confer, they both talk about it, and they have to jointly make a decision. There's sole legal decision-making, which is, just as it sounds, one of the two parties is going to make the decision about the child. And then there's something that courts have been doing for a while, and parties have been doing for a while, by inserting into their consent decrees provisions that will say that you can have joint legal decision-making with final decision-making authority to one of the parties. Now, the theory underlying that was always that the two parties would come together, confer, try to make a decision together, and if they couldn't, if there was some sort of impasse, then one of the two people would have final say, and they would get to pick. So that was going on for quite a while. Well, there was a recent case called Nikes v. Sundaram in which the Arizona Court of Appeals said that doesn't work. If you have a situation where you've got final decision-making authority, that is effectively sole legal decision-making. And we're trying to slap onto it a label of joint legal decision-making, but unfortunately that's just not what it is. So you can have a situation, and this is another thing that the court said, you can have a situation in which you have sole legal decision-making, but also impose a requirement that the parties first confer with each other, which would effectively create the same thing. But this idea that we've had historically of joint legal decision-making with final say can't really happen anymore because it is really just sole legal decision-making. So if you have an old order that has that language in there, going forward, be aware that it's basically going to be sole legal decision-making unless you go back and try to change it. Going forward, however, if you're creating an order and you've got this idea of final decision-making authority but a joint legal decision-making arrangement, just be aware that you can't do that anymore. And just because of this new case law, you're not going to be able to. If you have any questions about any of this stuff, you should always contact a family law attorney that is licensed in your state. In this case, we're talking from Arizona, and at least get some information about the basics of what's going on and what your options are.